Well, good morning, ladies and gentlemen. It's nice to see you all here early in the morning to hear a tax professor talk about a tax subject. My name is Leon Gabinet. I am the Coleman P. Burke Professor of Law at Case Western Reserve University. And my subject today is Poe versus Seaborn, a Contrarian View. Now, I understand that many of you have been out of law school for a long time. And some of you may have been through law school and not taken a tax course, so you may not be familiar with Poe versus Seaborn or its companion case, Lucas versus Earl. And actually, in order to understand Poe versus Seaborn and to understand what I'm going to say about what I think about Poe versus Seaborn, we really have to go back to the case of Lucas versus Earl. Both of these cases, Seaborn and Earl, were decided by the Supreme Court in 1930, quite a while ago. They dealt with the tax years 1927, 1926. And I will start with Lucas versus Earl. Mr. Earl, Guy Earl, was a very successful San Francisco lawyer. He had amassed quite a bit of money in the practice of law, and also he had made a considerable fortune investing in real estate with his brother. Now, Mr. Earl was getting on in years, and he was ill, and he decided that what he wanted to do was to pass all of his assets to his spouse, his wife, without any fuss, muss, or bother. In other words, he did not want a probate proceeding. Now, the state of California, which is where Mr. Earl lived, was a community property state, is a community property state. And the year that we're actually talking about is 1905. He did this in 1905. Although California is a community property state, which means that each spouse owns a half interest in all of the community property as property acquired during marriage, if Mr. Earl had died and the community property laws applied, his wife would get one half of the assets, but the other half would have to go through probate. In fact, everything would have to be probated in order to complete the transfer to his wife. That is exactly what he did not want. So he took advantage of a California statute, which we call a Transmutation Statute. That is, it permits spouses to opt out of the community property system by executing an agreement which says basically that we own our property not as community property, but as joint tenants with right of survivorship. Now that would mean, of course, that immediately upon Mr. Earl's death, all of his property would pass automatically to his surviving wife by operation of law without the necessity of having a probate. So this is kind of made to order for him, right? I'm sure that you're all acquainted with the tenancy, joint tenancy with right of survivorship. We live in a common law state where we have such tenancies, right? Lots of them. And many, many people use a joint tenancy as a will substitute. If you have a moderate estate, you own all your property jointly with your spouse, it passes automatically to your spouse without the necessity of a probate. So that was what Mr. Earl opted for. Now, 1905, remember, there was no income tax in 1905, right? Income tax didn't come in until the 16th Amendment was adopted, and that was 1913. And the first Revenue Act was 1913. So we're talking about a situation where there was no income tax. And what Mr. Earl did, he executed this agreement which said, essentially, from this date, all our property, whether it be separate or whether it be community properties, to be held as joint tenancy with right of survivorship, including all income. All income. And of course, he was the earner. So this was 1905. Well, along came 913. Now we have an income tax. And Mr. Earl takes the position that he and his wife each own one half of his income. That is to say, because of this agreement that he had executed, so that income also became jointly held, he took the position that his spouse had a vested one half interest in all of his income. And therefore, they could split their income. In other words, each one could report 1/2 of the income. And of course, what that would do is that it would lower the tax bracket in which they were each in, and the result would be much better, more optimal result than had his income been taxed, all of it at his high income tax rate. The government objected to this. The position was that, the taxpayer position was that from the moment that Mr. Earl earned the income, 1/2 of it belonged to his wife, because they had opted out of the community property system into this joint tenancy under the law of the state of California. The state of California permitted this. Well, eventually, this got itself up to the Supreme Court of the United States. The Board of Tax Appeals, which was the forerunner of the tax court, held for the government. The government position was, no, Mr. Earl, you cannot split this income between yourself and your wife. You are the earner. And we believe that the person who earns the income should pay tax on the income at that person's particular level. When it got up to the Supreme Court agreed with the government. And let me read you the paragraph from the opinion. And this is Mr. Justice Holmes speaking for the court. Okay, so we got Oliver Wendell Holmes, who was somewhat given to magisterial statements. And here it is. As I said, the taxpayer position was that from the moment that the income was earned, 1/2 of it belonged to Mrs. Earl. Mr. Holmes says, we might well hesitate upon the latter proposition because however the matter might stand between husband and wife, he was the only party to the contracts by which the salary and fees were earned. And it is somewhat hard to say that the last step in the performance of those contracts could be taken by anyone but himself alone. Now, here it comes, this magisterial statement. Wonderful. But this case is not to be decided by attenuated subtleties. Oh, we're not going to bother with the subtleties of title, right? I mean, who cares what the law of California says, right? That's an attenuated subtlety. Now, I looked up attenuated just to make sure I knew that it meant diminished. Actually, it means thin, made thin. And I guess when you say that something is an attenuated subtlety, you mean you have to mean that it is the most subtle of the subtle. Okay, it is utterly subtle. So, title, ownership, that's an attenuated subtlety, and we're not going to pay any attention to that. It turns on the import, the case that is, it turns on the import and reasonable construction of the taxing act. There is no doubt that the statute could tax salaries to those who earn them and provide that the tax could not be escaped by anticipatory arrangements. Another wonderful phrase, anticipatory arrangements, and contracts, however skillfully devised, to prevent the salary when paid from vesting even for a second in the man who earned it. That seems to us the import of the statute before us, and we think that no distinction can be taken according to the motives leading to the arrangements by which the fruits are attributed to a different tree from that upon which they grew. That wonderful horticultural metaphor, right? Which in the end created more confusion than it was actually worth. But in any event, the court says, we're not going to pay any attention to ownership. Ownership is not important here. We're construing a federal statute, and we're going to construe it as we think is reasonable and proper. And what we have here is a federal statute which creates a tax which is graduated, right? We have a graduated income tax. And I guess the whole point of this is that in order to preserve the integrity of the progressive rate structure, you cannot let people, by anticipatory assignments, assign income to somebody else and then say, well, yeah, I earned it, but then I executed an assignment. The assignment is valid under local law. Yep. But the court says we don't care whether it's valid under local law or not. We're not going to pay attention to that kind of stuff because it's an attenuated subtlety, right? So what becomes important here? Not ownership. It's not a question of who owns the income. It becomes a question of who earns the income, okay? Now, it seems to me that that is a reasonable, justifiable, logical construction of the statute. I really don't think there's anything wrong with it. Matter of fact, I like the decision. I like Lucas versus Earl, always have. if you're going to have a progressive rate system and you want to preserve the integrity of that rate structure, you cannot have people by anticipatory assignments of any kind assigning income to other persons, and in that way degrading the progressive rate structure. So it has always seemed to me that this was a perfectly reasonable, logical, good case. Well, along comes Poe versus Seaborn, decided in the same year by the same court about 7 months later, after the Lucas versus Earl decision. Now we have a case that comes out of the state of Washington. It's sort of my corner in the world up there, Pacific Northwest. The state of Washington, for some strange reason, although it was never under any civil law influence, I mean, there was no Spanish influence up there and certainly no French influence the way there was in Louisiana, state of Washington adopted a community property regime. So like California, it had community property. The Seaborns were residents of Seattle, and when the income tax came along, what the Seaborns did was that they said, well, okay, under the law of the state of Washington, community property state, 1/2 of all our assets, 1/2 of the assets belong to husband, 1/2 of the assets belong to wife, and that includes income which is earned, and therefore, under the community property law of the state of Washington, we can split that income between husband and wife based upon the proposition of ownership, right? I mean, how else can you do it? How else can you attribute the fruit to another tree upon which it grew unless you say ownership is important? So the taxpayer here takes the position that by virtue of the law of the state of Washington, community property regime, automatically, as soon as the husband earns income, half of it becomes the wife's income. Exactly the same thing that Mr. Earl was saying, not by virtue of the community property laws of California, but by virtue of the agreement that he and his wife had executed under the law of the state, turning everything into joint tenancy. Well, this case again wends its way up to the Supreme Court because the government took the same position in Seaborn as they took in Lucas versus Earl, namely that income should be taxed to the person who earns it. And here we get a totally different decision. Here the court says, oh, we have to pay attention to the law of the state of Washington. And income, a decision concerning income, is impacted by the law of the state of Washington. We have to pay attention to the state law. And the state law determines who the income is taxable to, whose property it is. Now, in the state of Washington, and in about 7, by the way, there are 9 community property states still today. State of Washington is still one of them. In most of those states, when we say that the wife has half the property and the husband has half the property, undivided interests, vested undivided interests, the husband in 7 of those 9 states has total control. That is to say, the husband decides what is bought, what is sold. The husband decides whether a sale is going to take place or not, whether there will be an exchange, what is to be acquired, etc., etc. You would think that that amounts to ownership, would you not? But the Supreme Court says, no, we don't care that the husband has control. The question is, where is the title? Who owns the income? So all of a sudden, what was an attenuated subtlety in Lucas versus Earl becomes an unattenuated subtlety in Poe versus Seaborn, and the court decides that in a community property state, half the income is taxable to the husband, half the income is taxable to the wife. If you happen to live in a non-community property state like Ohio, too bad, you can't do that. We don't have community property, right? And if you execute some kind of an agreement which makes the property joint tenancy with right of survivorship, you can't do that, right? We're not going to pay any attention to it because that is an attenuated subtlety. So what happened as a result of Poe versus Seaborn? Well, there were a number of terrible things, really, that came about as a result of this. First of all, you have a geographic disparity in the application of the tax laws, right? If you happen to live in one of the community property states, which, by the way, are Louisiana, Texas, Louisiana, Texas, New Mexico, Arizona, California, Washington, Nevada, and Wisconsin, of all things, Wisconsin. Another place where there was no civil law influence. Well, if you happen to live in one of those community property states in 1930, well before 1948, that's another important date, you can split your income and therefore get a much better tax result than you could if you lived in the state of Ohio or Illinois or Indiana or some common law state. That was a terrible situation. What happens as a result of this disparity in application of the law, geographic disparity? The legislatures of common law states are not dumb. So what they do is they begin to manipulate state law. In other words, if we are really going to pay attention to state law and the application of the federal tax laws, then let's do something about the state law. So what happens is that a bunch of states that never had any civil law influence at all suddenly become community property states by act of the legislature. That includes my own state, Oregon, Idaho, Wisconsin at that time, Colorado, Oklahoma. None of these states ever had any kind of Spanish influence, and all of a sudden they become community property states. For what reason? To give their citizens the same advantage as the Seaborns got in the state of Washington. Well, that is not the only problem. There were other problems that arose from this, but there was a lot of commotion about Poe versus Seaborn, and as a matter of fact, over the years there were attempts to get Congress to overrule the result. Actually, in effect, a legislative repeal of Poe versus Seaborn, because it was felt that it was not fair. It simply was not fair to have people who live in community property states have this enormous advantage over people who live in common law states. Nothing happened. They were not able to get the political support to overturn Poe versus Seaborn. But in 1948, after the war was over, the war, my war, that's the Peloponnesian War, In any event, in 1948, we got the grand legislative fix. Okay, so what happened in 1948? Along comes Congress and says, okay, it's time to fix this. We're having a terrible time. Let's have a joint filing option. Okay, we'll let everybody, whether you live in a community property state or whether you live in a common law state, we'll let husbands and wives file a joint return. And the effect of that joint return will be that effectively the income will be split between the husband and wife. All this is done, by the way, through the rate structure. There's a special rate structure which is established for husbands and wives filing jointly, and the effect of it is that income is considered to be half the husband's, half the wife's, and taxed at a specific rate which applies to married persons filing jointly. So you would think that does it, right? Now we have people in Ohio who are able to file a joint return and their income is split between husbands. Well, not quite that simple. One of the terrible things that happened as a result of this congressional manipulation was that we got something called the marriage penalty. Okay, what is this marriage penalty? Well, the marriage penalty adheres in the way they set up the rate schedule. That is to say, the rate schedule for married people is not the same as a single person filing separately. It is a different rate structure, and in effect, it is a higher rate structure than would be the case if you had simply taken half the income and treated it as though it were earned by a single person. So in other words, the rate schedule that was set up for single persons was not the same as the rate schedule that was set up for people married filing jointly. A marriage penalty. You paid a penalty in the form of a higher tax than if you were filing singly. Well, that was a bad thing, right? You've heard a lot about the marriage penalty, I think. And over the years, we've done some things to ameliorate the effect of the marriage penalty, but we have never quite entirely gotten rid of it. So that was something that arose, traceable to Poe versus Seaborn. If you hadn't had Poe versus Seaborn, you wouldn't need the 1948 legislation. So again, this is traceable to Poe versus Seaborn. What else happened? Well, you know, sometimes people file fraudulent returns. And what you get is an innocent spouse, right? You get a joint filing, and the minute you sign, both spouses sign that joint return, both of them are severally and jointly liable for the tax. Well, let's suppose that the husband files a return, and in effect, that return is fraudulent. The husband commits fraud in the execution of the return. Wife doesn't know anything about it. And she says, why am I liable for his fraud? You have an innocent spouse problem. And in order to deal with the innocent spouse problem, we got a whole set of legislation, statutes, in the Internal Revenue Code, and page after page after page of regulatory material concerning how to treat an innocent spouse and how an innocent spouse can get what is called innocent spouse relief. It complicated the code enormously. So that was another aspect of the problem. That was not all. Think about divorce for a minute, okay? What happens if you get divorced in a community property state? Well, if you get divorced in the community property states, in 6 out of the 9 community property states, property is split evenly between the husband and wife. At least community property is split evenly between the husband and wife. In other words, you have a kind of equitable division which demands an equal split of the property. Okay? What do you get in a common law state? Well, we have today equitable division, but equitable division, of course, doesn't mean that the property is necessarily split half and half, that you get an equal division. It depends on your agreement, and it depends on what the court thinks that the split ought to be. So, in any event, in a community property state, half the property goes to the husband, half the property goes to the wife. In a common law state, it may be necessary for the husband and wife to make exchanges of property. And this is often what happens. So suppose, for example, that you live in the state of Ohio, not in California or Texas or Louisiana, and you're going to be divorced from your spouse. And you say to your spouse, I'll tell you what, I have $500,000 worth of IBM stock. I bought it for $200,000. Okay, I'll tell you what, I will give you the IBM stock, and you relinquish all your marital rights in my property. In other words, there's going to be an exchange. I give you the IBM stock for consideration. The consideration is that there will be a relinquishment of all other marital property rights. Okay, what happens in a situation like that? Along comes the Supreme Court in 1962 in the Davis case, U.S. versus Davis. And they say, that is a taxable transaction. Okay? Now, consider, when you have an equal split of the property in California, that is not a taxable transaction. That's just a division of the property incident to a divorce, right? Well, here we have essentially the same thing, don't we? There's going to be a splitting of the sheets in Ohio. But if the split takes place in the form of an exchange of appreciated property which is appreciated in value over its basis, over its cost, then let's say the husband is the transferor, wife is the transferee. Then that is considered by the Davis case, according to the Davis, a taxable exchange. It is as though the husband sold the property to the wife for the value for marital property rights. And the marital property rights are assumed to be equal to the value of the property which is transferred. So in my example, a $500,000 transfer of IBM stock with a basis of $200,000 in consideration of the relinquishment of the marital property rights would result in a $300,000 gain to the husband, in this case, taxable. Now, you think about that case and you say, for heaven's sake, in a community property state, that would not happen. equal division of the property, right? Even if there is an actual exchange in order to effect the equal division. Tax-free. But in a common law state, Ohio, New York, Connecticut, that doesn't happen. We got the Davis case, 1962, a much hated case. Right? It was very unpopular in the domestic relations community, as you can imagine. Where did the Davis case come from? Well, the distinction between the community property states and the common law states, which again finds its origin in Poe versus Seaborn. Well, we got another grand legislative fix. Okay? There was a lot of to-do about the Davis case, and the legislative fix that we got was Section 1041 of the Internal Revenue Code. Okay? Section 1041 of the Internal Revenue Code. What does that say? It says, if there is a transfer of property from one spouse, transferor, to another spouse, okay, an interspousal property transfer, or to a former spouse incident to a divorce, okay, then no gain or loss shall be recognized. So what are we doing? Okay, we're fixing it up, right? We're saying away with the Davis case. From here on in, this is not going to be a taxable transaction. We're going to have a tax-free transfer of property incident to a divorce, and that sort of fixes it. Well, it doesn't. Okay? A lot of bad stuff flows out of Section 1041. As a matter of fact, I wrote an article, which was, I think, in the case Western Reserve University, Law Review, as I recall, in which I took 1041 to task. I called it the quick fix. Quick fixes often have serious consequences, and this did. For example, first of all, Section 1041 also says that once an interspousal transfer takes place, the transferee spouse takes the transferor's basis in the property. Okay, so there is a substituted basis. If there's husband transfers the property to the wife, wife takes the husband's basis in the property. So if you have appreciated assets, let's say the house is being transferred from husband to wife. Now the wife owns the house. If she later sells that house, there is a large gain. Well, Section 121 takes care of that, right? We don't recognize the gain on the sale of a personal residence. So let's say the transfer is IBM stock instead. Now we have a different story. Wife sells the stock. She bears the burden of the tax because she has taken the husband's basis. Okay? So in my example, if she were to sell the IBM stock for $600,000, she'd have a $400,000 gain down the line. So now what we've done is that we have shifted the burden of the tax to the wife. What that means now is that you get a lot of negotiation about who's going to pay how much alimony in order to equalize this. You know, it becomes a bargaining chip, becomes a bargaining issue, and it complicates the bargaining in a divorce immensely. But that isn't the only problem. When is a transfer incident to a divorce? How about a transfer 6 years after the divorce? 5 years after is it incident to the divorce? So you got that problem. But you got a much more serious problem. We don't allow anticipatory assignments of income, right? We saw that, Lucas versus Earl, and I said that was okay. And I think it is okay. But here comes Section 1041. And suppose that instead of transferring IBM stock, husband transfers an income stream to his spouse. Okay? Something which would be taxable as income to the husband. Suppose, for example, that the husband is a lawyer. This is an actual case, by the way. It's the Kochansky case decided in the tax court. Husband is a lawyer. He's got a great big fee coming from a personal injury case, something in excess of $300,000 fee. And he says to his spouse, this is a divorce negotiation, I will transfer to you, I will assign to you as part of our property settlement the right to receive this fee that I am about to get. Oh, he has made of an anticipatory assignment of the right to receive income, right? After all, who is the appropriate taxpayer here? Of According to Lucas versus Earl, the appropriate taxpayer is the husband, the guy who earned the fee, right? So, notwithstanding so the question becomes, what trumps what? The Section 1041 trump the anticipatory assignment of income doctrine established in Lucas versus Earl, or does anticipatory assignment trump Section 1041? Well, according to the tax court, the principle established, the general principle established in Lucas versus Earl prevails. Okay? There is an anticipatory assignment of income here, and notwithstanding Section 1041, and notwithstanding the fact that this is a divorce-related transfer, a transfer incident to a divorce, the husband remains taxable on that income stream by the application, not of Poe versus Seaborn, but of Lucas versus Earl. So you get this problem in 1041. In other words, all the legislative fixes that were necessary as a result of Poe versus Seaborn have these inherent problems. Okay? And in a way, of course, any time you're going to codify something and you're going to put it in the Internal Revenue Code, you're going to have definitional problems. You're going to have all kinds of problems. And this is exactly what happened. And all these problems are traceable. As you can see, I don't like Poe versus Seaborn. Right? Matter of fact, I kind of hate Poe versus Seaborn. In any event, that's that problem. That's not the end of the litany of problems that arose from Poe versus Seaborn. Let's consider death. Okay? Let's consider a community property state. Husband owns half the property, wife owns half the property. Husband dies. Okay? Now, what happens, of course, when husband dies, the half of the property, which is included in his estate, is subject to estate tax, federal estate tax, right? The other half, of course, belongs to the wife. The question is, what happens to the basis of property in a community property state once one of the spouses dies? We have Section 1014 of the Internal Revenue Code. And Section 1014 of the Internal Revenue Code says that when a decedent dies, the basis of the property which passes to his heirs is stepped up to fair market value at the date of death. Okay? There is an immediate jackup in the basis of the property from its cost to its fair market value at the date of death. Well, in the community property state, the courts have taken the position, and this is the interpretation, it's in the code, in a community property state, the entire value of the property, not just the half which is included in the husband's estate, but also the half that the wife gets, which is not included in the husband's estate, all of it gets a step up in basis. Okay? Why is that? Well, because the theory is that under Poe versus Seaborn, the wife is getting her interest through the estate. Okay? Somehow it is considered to pass through the estate. It blows my mind. That was not considered to be the case in Poe versus Seaborn, right? Automatically becomes the property for income tax purposes. Oh no, but for estate purposes, it passes through the estate, and therefore it takes a step up in basis. Both halves get a step up in basis. If somebody dies in the state of Ohio and has joint property with right of survivorship with a spouse, what happens is, again, half the property is included in the estate, half the property is not included in the estate, but the basis increase is only for the half which is included in the estate. Okay? So what have we done? We've created, again, a geographic disparity in the application of the estate tax, the basis rule, depending upon whether you live in a community property state as opposed to whether you live in a common law state. It ain't fair. It ain't logical. It is not justifiable in any way. And again, it is traceable to Poe versus Seaborn. All right. So now we've got a litany of problems which have come from Poe versus Seaborn. We have tried legislative fixes. The legislative fixes have presented problems of their own. And this is where we are today. Now, you might say, well, all this is kind of ancient history, right? I mean, what does it matter? We're stuck with it. For better or for worse, we have Poe versus Seaborn. Well, let's jump forward. Well, actually, let's jump geographically. to the state of California, where lots of funny things happen all the time. In the state of California, you know, we live today in an era of same-sex marriage. We've got same-sex marriage in Massachusetts, Connecticut, New Hampshire, Rhode Island, Washington, D.C., New York. We also have civil unions in many of those states. Civil union, of course, is not exactly a marriage, but most of the civil union statutes provide that the people who same-sex couple have all the rights and benefits and burdens of spouses. Okay? Well, California in 2003 adopts what is called the Registered Domestic Partners Act, okay, RDP, the Registered Domestic Partners Act. What is that? It's basically a civil union statute. Okay? It provides that same-sex couples, any same-sex couple, parties over the age of 18, and also anybody who is over the age of 62, whether same-sex or not, can execute an agreement by which they establish and register as domestic partners, registered domestic partners. It's a civil union statute, and the statute specifically says that these people have the same rights and obligation as spouses. Okay? Well, there's a problem here because we also have a federal law called Doma, D-O-M-A, right? What is Doma? Doma is the Defense of Marriage Act, okay? The Defense of Marriage Act enacted in 1996 when Bill Clinton was president, and he signed it into law. And let me just read you the applicable section in the Defense of Marriage Act, which I happen to have right here. It says as follows: in determining the meaning of any act of Congress or of any ruling, regulation, or interpretation of the various administrative bureaus and agencies of the United States, the word marriage means only a legal union between one man and one woman as husband and wife, and the word spouse refers only to a person of the opposite sex who is a husband or a wife. That's the Defense of Marriage Act. For all purposes of federal law, a marriage is between persons of the opposite sex, and a spouse has to be a person of the opposite sex. Okay. So no matter what California does, or any of the civil union states, or in fact Massachusetts or New Hampshire with its same-sex marriage, for purposes of federal law, that same-sex couple are not spouses. They cannot file jointly, okay, because the joint filing privilege refers specifically to spouses. So notwithstanding the enactment of the Domestic Registered Partners Act, the RDPs, in California, these people could not file. California residents could not file jointly. Okay. Well, also, the community property laws only covered husbands and wives in California. So community property did not apply to domestic registered partners. Well, along came 2006, and the California legislature said, that is an oversight. We're going to fix that. From here on in, starting in 2007, same-sex couples who file as RDPs in California are covered by the community property laws of the state, and any property acquired during the existence of that relationship is community property, just as in the case of husbands and wives. Well, now the question becomes, having extended the community property laws in California to cover registered domestic partners, what does that do to the application of Doma? Okay, because if Poe versus Seaborn is now going to apply, we've got community property covering RDPs. If Poe versus Seaborn applies, they ought to be able to split their income, right? So the question now becomes, by virtue of the extension of the community property laws to cover RDPs, Does Poe versus Seaborn now apply so that each of them can split their income, right? That was the whole thing. Ownership, right? Who owns the property? If we now have community property covering the RDPs, then the principle of ownership should apply, and they should be able to split the income between them. So the Internal Revenue Service is asked to rule about the application of Poe versus Seaborn in this situation. Well, the Internal Revenue Service issues two advisory opinions. Okay, the first advisory opinion, this is 2010, by the way, we're now into 2010. 2010, the Internal Revenue Service says, no, Poe versus Seaborn doesn't apply. Why? Because Poe versus Seaborn is intended to apply only to husbands and wives. Okay, that is the history of the community property laws. This applies only in the marital situation. It does not apply outside the marriage. RDPs, even under laws of California, although they're treated the same as spouses, they are not married, and therefore Poe versus Seaborn doesn't apply. Doma applies, and therefore they cannot split their income. Well, it wasn't much later than that. As a matter of fact, just a few months later, in 2010, the Internal Revenue Service does a 180-degree turn. And it issues another advisory opinion in which it says, we retract that former advisory opinion. We think that Poe versus Seaborn does apply here. It's a question of ownership and not of marriage. Okay? Therefore, since California has now changed its law to cover registered domestic partners, now they can split their income. Okay? Poe versus Seaborn applies again in this situation. Well, now, naturally, this second opinion is greeted with great joy in the gay and lesbian community. Why not? They are now entitled to split their income just like everybody else, right? Well, there is a Domestic Registered Partners Act in Oregon. There is a Domestic Registered Partners Act in the state of Washington. There is a Domestic Partnership Act in the state of Nevada. So now, Oregon is not a community property state. So no matter what happens in Oregon, RDPs cannot split their income. No community property, and Oregon is not about to enact community property again in order to make it possible for RDPs to split their income. So what we have established again is a geographical disparity in the application of the tax law. Because if you happen to live in a community property state where the community property is going to cover RDPs, those RDPs can split their income. If they happen to be unfortunate enough, well, they're lucky to live in the state of Oregon no matter what. But if you're an RDP living in the state of Oregon, you cannot split your income. You can in Washington, you can in Nevada, you can in California, but you can't in Oregon. And you can't in New Hampshire or Massachusetts or Rhode Island or anywhere else where they have a civil union. Those are not community property states. So now, in the gay community itself, in the same-sex community itself, we have established geographic disparity again. It's Poe versus Seaborn. There it is. And then the question arises, what the heck are we going to do with Poe versus Seaborn if the states should decide to manipulate their community property statutes in order to cover relationships other than RDPs? Okay? Suppose the state of California, where lots of peculiar things happen, were to say, we're going to extend our community property statute to cover any committed relationship. Okay? And we'll define a committed relationship, whether it be same-sex, whether it be heterosexual, doesn't matter. And we're going to extend our community property laws to cover that relationship. Now are we going to say, well, Poe versus Seaborn applies again, and notwithstanding the fact that people may not be married, okay, and they may not be married, they may not be registered domestic partners. Nevertheless, if we choose to extend community property to some other kind of relationship, then those folks can split their income. In other words, now we have an end run around Doma. Okay. First of all, let me make it clear that I am not a friend of Doma. I think it's a terrible piece of legislation. I think we ought to get rid of it. There are now 3 federal courts, 3 federal district courts that have held Doma unconstitutional. It is on its way to the Supreme Court, inevitably. I can't say, I don't know what the Supreme Court is going to do with Doma. I'm inclined to think that maybe this Supreme Court is not going to declare it unconstitutional. On the other hand, I think the push is in Congress, the push legislatively, whether we have a Republican or a Democratic Congress, I think inevitably there will be a legislative repeal of Doma. And what I think ought to happen is that, yeah, I think that we ought to get rid of Doma, and not to have an end run around the statute. Let's just eliminate Doma. Not make it possible to extend community property in a way that it was never intended to be. The first opinion, the first IRS opinion to the effect that community property was intended to cover husbands and wives is historically correct. It was never intended as anything else except a regime to cover property relations between husbands and wives derived from the civil law, from Roman law originally. I think, in addition to getting rid of Doma, what we ought to do is get rid of Poe versus Seaborn, frankly. Just get rid of it. If we did, and I think, and this is why I think it's a contrarian view, because not very many people hold this view. I think that, yeah, we ought to get rid of Poe versus Seaborn, and we ought to go back to a system where property, where income is taxed to the person who earned it. Let's preserve the integrity of the progressive rate structure. You might say, well, but then what happens to the joint filing privilege? You say, let's get rid of the joint filing privilege too. And in its place, let us have a realistic, realistic standard deduction and a realistic personal exemption with in a where we have persons cohabiting and supporting other people, dependents and other people, where we have some rules which allow the attribution of deductions and personal exemptions in a manner which relates to the contribution which each makes to the income of the couple. I think that makes perfectly good sense. In other words, we don't really need joint filing. And we don't really need all of the evils that arose from joint filing. Let's get rid of the innocent spouse rules that have complicated the Internal Revenue Code. And in addition to that, let's fix if we're going to have an estate tax, at least let's fix the estate tax so that you don't get a step up in basis for property which never passes through the estate and which might actually be willed to somebody else, which is the case in any community property state. That could happen. That is my view in the end. And as I say, it's a minority view. And it may never come to pass because we have established a love affair with the joint filing privilege. It's embedded in the law. It's going to be very, very hard to get rid of it. But I think that the principle that was established in Lucas versus Earl is the appropriate tax principle. If we're going to make common law of taxation, that should be the guiding principle. That income is taxed to the person who earns it and not to somebody else, and that it ought not to be attributable to somebody else by virtue of anticipatory assignments, however skillfully devised. Now, I wanted to leave about 10 minutes for questions, so I will do that. Yes, sir.
Do the states that aren't community property states, have they attempted, or any legislation attempt to correct this inherited basis problem?
No. No. They have not. And there's no way you can do it. They cannot do it legislatively. It has to be an act of Congress. It's in the Internal Revenue Code. So only Congress can fix the Internal Revenue Code. Now, yes, and of course, then there ought to be a push to do that because there is no justification for that difference in basis.
The other question is, are there any cases coming up through the lower courts?
Not that I know of. Not that I know of. There has been a lot of talk now about doing away with Poe versus Seaborn. There is, in the academic community, there is some talk about doing away with Poe versus Seaborn, particularly because generally in the academic community it is believed that the Internal Revenue Service was dead wrong in its second advisory opinion. But whether or not that can happen, whether or not that can be pushed through Congress is a different issue. But we academics like to think about it. Yes?
Just a question. Conceptually, with regard to Lucas versus Luke, is it Luke versus Davis?
Earl versus Lucas.
Earl versus.
I'm sorry, Lucas versus Earl.
Lucas versus Earl.
Yeah.
Would you think that the whole concept that we have of alimony these days is actually a transfer of earned income to somebody else who's not earning it? And that you're incentivizing, through that decision, aren't you incentivizing people to get divorced who have substantial income and transfer their, because alimony seems to be an exception to Lucas versus Earl.
No, I don't think so. Because what happens when you pay alimony, of course, the alimony is taxable to the recipient, the person who receives it. But the person who earns it, the person who transfers it, gets a big deduction, right?
That's right.
So, and I think
he's essentially
that
transferring
actually,
his
the taxability of alimony to a recipient can be justified on this theory that although, let's say it's the husband paying alimony to the wife, okay? Although the husband earned the income, the husband does not have the consumption privilege, okay? Who actually is going to get the consumption benefit of that transfer? It's going to be the transferee. So if you think in terms of consumption benefit, the transfer of the consumption benefit justifies the tax to somebody else. Okay.
Even if it's
and besides,
not
I really don't think that people get divorced or do not get divorced, depending upon who's going to pay alimony necessarily or how much.
Okay.
Oh, Mr. Carlini. I knew there was a plant in the audience. Former student.
The IRS has generally used state law to decide questions like this, but it sounds like in this instance, it's all screwed up. Is that sort of accurate?
Yeah. My view is, in interpreting a federal statute, why should we care about the state property law? It's an attenuated subtlety, right? Who cares? We're interpreting a federal statute, and it ought to be interpreted by the federal courts in accordance with federal law. You know, there ought to be a federal common law about these things, not a state common law of property or state statutory law of property. That's what created it. Well, you're right. It screwed things up, Larry. Yeah. Anyone else? Okay, if not, thank you very much for your attention. It's been a pleasure.